R 273. Counsel, yesterday the state rested. Attorney Sisti, do you have a motion to make at this point?
I do, Your Honor. Thank you for the opportunity. First of all, I'd like to incorporate all the arguments that related to the motion to dismiss it.
Yes, of course.
We have alluded to that earlier. The state has rested. Self-defense, deadly force is still viable. And we would set forth that the prosecution has not negated it at this juncture. There hasn't been adequate response with regard to that position, whether it's being reflected in statements of both Jason and his daughter or reflected in the video. The last witness, in fact, confirmed that Jason would have been accurate by stating that it appears from the statement in the video that Violette initiated contact, that Violette stuck his face into Jason's face, that there were threats made, that Violette appeared agitated and upset. I'd also note that I'm going to bring back one other issue here, and that's the missing witness. I know it's been litigated, but the state has rested, and it is now 10:41 a.m. on the 19th of March in his trial, and he has not been afforded the right to confront his accuser face-to-face at this trial, contrary to the Sixth Amendment of the U.S. Constitution, Part 1, Article 15 of the New Hampshire Constitution. That's an essential right. It's nothing new. It's been articulated over and over again from the beginning of our nation. I'd also state that there are insufficient facts that have been adduced by the state to counter the claim of self-defense, thereby defeating the criminal element, the critical element of the case, and that being the state must disprove self-defense beyond a reasonable doubt. And what I'll do is I'll ask the court to incorporate its proposed self-defense instruction with regard to that. I need not be every word in that, but I ask the court to reflect, or actually the record to reflect. We do have a proposed instruction on self-defense. I expect that will be the one that we are working with. If I need to have that marked now, I would. But I think all parties would agree that's what we're going to do here today. There hasn't been any objection to it, although I have to say we do have one minor mistake on it,
Which we can take up after this argument. I'm happy to hear that. Actually, that raises something because overnight I went through my jury instructions and made some adjustments to the self-defense instruction, which I need to share with both parties before we get to that part of the proceeding. Specifically, I'm going to add, I think it makes sense, and we can talk about this more. The self-defense instruction references serious bodily injury, but never defines serious bodily injury. And elsewhere in the instructions, I define bodily injury because of the First Amendment. The first degree assault. I think it makes sense if I'm going to say something about serious bodily injury in the self-defense instructions that I should define serious bodily injury. So I've added some language defining serious bodily injury, and I've also just changed a little bit of the phrasing for grammatical, editorial reasons. But I want you to see that before we get to instructions. So we'll make sure there's time for that. So go ahead, counsel. I'm sorry.
So specifically, I'd like that incorporated. Next, I'll just move on to the attempted murder aspect. Again, I think there's a flaw there with regard to the mens rea. It requires, with regard to that particular charge, the information videos and testimony indicate that we're dealing with a reaction not initiated by Jason to the actions of the alleged victim, which would fail to establish that Jason had requisite mental state at the time of the shooting, and would also establish that he didn't have the purposeful intent to kill at the time. I know that there is after the fact video that's been introduced at this trial, but the after the fact video does not necessarily reflect an instantaneous reaction of an individual to his position. And then I'll just incorporate the self-defense argument that I've already made with regard to first-degree assault indictment. Those are the basic areas that I'd ask the court to reflect upon and would ask for dismissal of both offenses.
Thank you. State?
Thank you, Your Honor. Specifically regarding the self-defense argument that the defense has raised, and I think it's important we remember that the view the court is to take in this moment is in the light most favorable to the state and all reasonable facts and inferences. In that view, a reasonable jury could absolutely find that the state has overcome defense's affirmative defense of self-defense in this particular case. The jury has seen numerous videos in this case that demonstrate that any kind of altercation that was previously going on between the defendant and Mr. Violette, any kind of previous interaction outside in front of the plow, had ended at the point wherein the defendant pulled out his gun and aimed it at Kyle Violette. They were many feet apart at that point by all estimations, other than I believe the defendants the night of, 15 feet or more away from each other. Mr. Violette was going back into his own home. By Detective Daney's testimony, which the jury did hear, you can actually see in the shadows the way that his feet were turning. So even after he had turned back to look at the defendant, the victim's feet were moving in a way that suggested he was turning further away after he saw the defendant pull out his gun. The altercation had been ended at that point. It's in this moment that the defendant shot Mr. Violette the first time, which hit him in the face. He then proceeded to shoot him 5 more times while Mr. Violette crawled on the ground. But that 5 more times didn't occur until after about 3 or 4 second pause. And during that pause, the defendant actually put the gun down, paused, and took several steps forward in order to get closer to Mr. Violette in order to shoot him, presumably more accurately. But in order to, when those shots were happening, he was stepping, in fact, closer to Mr. Violette while he crawled on the ground. Regarding the mental state in this matter, that can truly only be indicative of a purpose. As Your Honor is aware, mental state can be established, to use defense's word, instantaneously. This does not have to be a premeditated thought that days before, weeks before, even minutes before he decided to shoot Mr. Violette, the defendant made that conscious decision. It can be a decision that is decided in an instant, and in this case, I do believe that is what we are talking about. I'd also refer, Your Honor, to specifically the self-defense statute 627-4, which states a person is justified in using deadly force upon another person when he reasonably believes that such other person is about to use unlawful deadly force against the actor or a third person. Specifically regarding, that does seem to be the main focus here. There are additional other times where the statute allows for it, but that seems to be the major issue here, is there's no issue of burglary or kidnapping or anything along those lines. There has been no allegation that Mr. Violette had a weapon. The detectives have already said that he did not have one when they got there. The officers that responded stated that when they were performing the medical aid, they did not see a gun on him. They did not see any kind of weapon on him. The defendant himself, as you heard through Detective Garson yesterday, stated that Mr. Violette's hands were empty when he was walking over to the plow area and while they were having that conversation. He stated he did not think Mr. Violette had a weapon. The defendant's own daughter stated that she did not think that he had a weapon, or she had no reason to think that he did. So all we're talking about in this moment are words. That, when viewed with the timing issue here of Mr. Violette turning and walking away back towards his own home, there is no imminent deadly threat. And a reasonable jury could have found that the state has proved that and thus overcome the self-defense issue. The other portion of the self-defense statute I want to refer Your Honor to is that a person is not justified in using deadly force, this is Roman numeral 3, on another to defend himself or herself or a third person from deadly force by the other. They know that they can with complete safety comply with demand that they abstain from performing an act that they're not obligated to perform. That's a conditional threat. All of the testimony about an alleged threat made by Mr. Violette include the language, if you do this, I'm going to do this. If you keep plowing the fucking snow in front of my driveway, I'm going to kill your family, is the threat that we've heard time and time again in this particular case. That is the definition of a conditional threat, Your Honor. If X, then Y. And both the defendant's daughter and the defendant were consistent in their statements to police when they were describing any kind of potentially alleged threat heard. That being a conditional threat, and the jury hearing Your Honor's instruction about it, as well as ultimately as this case goes on, a reasonable jury could find that because this threat was conditional, that self-defense is not justified in this particular case, especially when viewed with the fact that when that deadly force is viewed with it, where there was no allegation of any kind of weapon, any kind of specific aggressive action toward any particular person in this case, other than getting close in physical proximity. There wasn't a strangulation, there wasn't a hit. I'd also refer to Your Honor, the only threats that, the only physical risk that the defendant was able to articulate in the statement to police was a fear that that Mr. Violette might hit him, or that he might move forward to him and potentially take the gun away from him when he had pulled this gun. That is not an imminent deadly threat or threat of serious bodily injury, just on its face. A threat to a punch is not facially serious bodily injury. The jury's heard not quite extensive, but I think accurate and voluminous testimony at this point about the injuries suffered by Mr. Violette at this case. So to the extent that the risk of death is an issue, which I don't believe it is, because I didn't hear the defense raise it, but I, for the record, will make that argument, that has been more than covered by Dr. Priest, who was able to articulate the 3 different hospitals that Mr. Violette went to within fairly short succession that night, and then ultimately spending several weeks at Boston Memorial, where he underwent multiple surgeries. We were able to hear from Detective Daney, who collected one of the bullets that was retrieved through Mr. Violette's face after he underwent surgery. At that point, they were able to see the body camera footage of Sergeant Williams Hurley, who was performing the life-saving medical treatment, as well as her testimony from the paramedic in this case, all of whom described the very serious nature of these injuries that Mr. Violette was suffering, and articulated that if not for this intervening medical treatment, he would have died. So that element is absolutely established at this point by the state, Your Honor. Just one moment. It's for those reasons, Your Honor, that the state does believe a reasonable jury could find, in the light most favorable to the state, that not only has the state proven these charges beyond a reasonable doubt, but that we have actually overcome defense's self-defense claim by defending guilty.
Okay, thank you.
Very briefly,
Okay.
Of course, the court knows that there's no need for a weapon to have been found. That's an interesting argument. It's also irrelevant. Actually, it's not a fact that's in any contention. With regard to Kara Violette, Kara Levesque's testimony, she did state that she felt threatened and that they were in danger. And that's uncontradicted. I'll also state that physical motion, physical activity can act as threats. Those would include surprising somebody coming up on them without notice and physically sticking their face in their face, unprovoked and uninvited. And in total context of the situation, this not only was not a conditional threat, it was an actual physical threat. And with an actual physical threat, you do not dance around conditional or otherwise. But there has been information produced that, in fact, Kira, in her testimony, stated that there was an actual threat. She sensed it. So with that, Your Honor, I will rest on it.
Okay, thank you. Having heard from both parties, having reviewed the evidence in this case myself, I'm going to deny the motion. I think viewing all of the evidence in the light most favorable to the state, as I'm required to do at this point, and drawing all reasonable inferences from that evidence, as I'm required to do at this point, I believe that a rational juror could find the defendant guilty beyond a reasonable doubt. I think the state has presented enough evidence, even without the victim in this case, to be able to potentially disprove self-defense. I think a jury could have doubt about all three of the prongs, basically, of the self-defense instruction. That is, whether the defendant actually believed that there was an imminent threat of serious bodily injury. I think the jury could conclude, based on this evidence, that even if he did believe that there was such a risk, that it wasn't reasonable. And I think a jury could also conclude, based on the evidence, that even if he reasonably believed that he needed to use force, that the amount of force was excessive. I base that upon primarily the video evidence, which I think is probably the most striking aspect of this case. I mean, when you look at the video evidence, you can clearly see that there is some sort of altercation, that the alleged victim is acting in a hostile, aggressive way toward the defendant. I think it's not a stretch to say that from that evidence you can see that the defendant is likely in fear that he's potentially going to be in a physical fight with the victim, that a physical fight is about to break out and he might be attacked. But I think when you look at all of the video evidence, and in particular the way the shooting actually unfolds in terms of when the defendant draws the weapon, you can see the victim appears to be turning to walk away when that first shot is fired. The fact that there's the three approximately second delay, at which point I think a jury could conclude the defendant did have an opportunity to think about the situation, to reflect for a moment. At that point, the video shows the victim crawling away from the defendant, at which point the defendant takes several steps towards him, raises the gun a second time, and fires 5 additional bullets. There's the medical testimony that suggests that all 5 of those shots struck the victim in the back. There is no evidence that the victim possessed a weapon, or that he appeared to be reaching for a weapon, that there was any evidence from which the jury could conclude that the defendant thought that the defendant was about to, say, shoot back at him. I think given all that evidence in its totality, viewing it in a light most favorable to the state, as I'm required to do at this point, drawing all reasonable inferences in the state's favor, as I'm required to do at this point, I think a rational juror looking at all the evidence could find that the state has disproven self-defense. As for the other elements, I think the mens rea element of the attempted murder case, I think the fact that the defendant then fires 5 additional bullets into the defendant, into his back, basically, while he's crawling away from him, is sufficient evidence from which a rational juror could conclude that he had the purpose to commit murder. That is, that he had the purpose to kill the defendant, kill the alleged victim. In terms of the first-degree assault, I don't think there's really any doubt that there's really no question from the evidence presented that the defendant did, in fact, cause bodily injury to the victim using a deadly weapon. I don't think that's really even in dispute. So the only issue on the first-degree assault case is the self-defense, and that, as I've already said, I think a rational juror could conclude that self-defense has been disproven beyond a reasonable doubt by the state. So for all those reasons, I'm going to deny the motion. And at that point, I think, are we ready to bring the jury back?
I'd like to renew a motion in anticipation of the defendant testifying. We talked about the limitation of the defendant to inquire on cross-examination about a prior, refer to it as a prior incident or prior threat allegedly made by Kyle Violette towards the defendant. And now I'd like to focus on whether the defendant actually has the right under the rules of evidence to testify to that event. My position is that analytically it doesn't change, that I'm certainly aware that in self-defense cases, instances of pertinent character traits known to the defendant can be addressed. I don't think that rule changes the analysis between how that evidence comes in, as opinion evidence in non-specific instances. I also would raise a 403 issue on this particular prior threat. Here's the basic claim that Jason Levesque made during that police interrogation or questioning. He said, probably 2 months ago, but then when asked for some type of framework, he said, well, it was in the fall. It may be early winter. That would be like November. He was out doing some chore on his porch. He says that that Kyle walks by and calls him a rat and says, if you call the police again, I'm going to fucking kill you and your family, invoking the exact same threat. But what he says transpires next is absolutely nothing. In other words, even assuming that there was a threat made some 6 to 4 months earlier, the relevance of that in terms of a self-defense claim against the use of deadly force is highly attenuated, but still quite prejudicial, and unfairly so. Because it's not a character trait for the actual use of force. It's apparently a character trait for mouthing off in similar fashion. If you do something, I'm going to fucking kill you and your family. That has very low probative value, and in fact, even assuming it's true, it doesn't change the dial on his ability to use deadly force in a given instance some 6 to 4 months later. And for that reason, I object even to the defendant testifying to that claim.
Thank you. Attorney Sisti?
Jason's going to take the stand. We expect to go into that claim. That's one of the factors that will go into his head at the time. And he explained that. This is an interview. We know we've been barred on hearsay. This is not hearsay. This is what he actually experienced. And I think we've actually discussed this at the bench. In fact, my understanding from the court was certainly incumbent to the defendant if he takes a stand and not to be investigating the fact that to a type of a hearsay exception. And I don't agree with that right now. And we're prepared to come to the stand and elicit all relevant information as to why he thought at the time, on April 4th, that he had to act in self-defense, and that he did have contact with Mr. Violette. Certainly wasn't pleasant, and in fact, it involved an actual threat to him and his family, much like that, which took place on April 4th. So yes, it's relevant. It comes in. It's an instance that does have an impact on how he operated and how he dealt with the situation on April 4th. And I certainly will, agree at this juncture, and it wipes out any issue, I take it, with regard to rulings under 803, 801. Today, we're in another ballpark. How he felt, what he experienced, and how he can firsthand explain his interactions with Kyle Violette.
All right, thank you. So the court, anticipating this issue, has done some research. I am going to deny the state's motion at this point, in part. I'm relying on cases, the following cases. I'm relying on State versus Woodburn, which is a 2023 case of the New Hampshire Supreme Court. This is 175 New Hampshire 645. I'm relying on State versus Vassar, a 2006 case, 154 New Hampshire 370. Both of those cases stand for the proposition that in cases where self-defense is raised, that the state of mind of the defendant is an important factor that the jury has to decide, and that under 404B, prior bad acts may be relevant for purposes of determining the defendant's state of mind at the time of the incident and whether he was reasonably in fear. If you look at State v. Woodburn specifically, they lay out the test that the court should apply in applying 404B in these circumstances. And to ensure that the prior bad acts are relevant for a non-propensity purpose, the proponent must demonstrate a sufficient logical connection between the prior acts, and the defendant's state of mind at the time of the charged conduct. The temporal proximity or remoteness is one factor which the court can consider in deciding whether there's a sufficient logical connection that exists. But both of those cases stand for the proposition that defendant's state of mind in terms of self-defense is an appropriate non-propensity reason to bring in prior bad acts under 404B. Now, that does raise the question which the state raised last time we talked about this, which was that my understanding is that 404B notice was never given in this case, which is a requirement in order to use 404B evidence. Normally, there has to be notice to the state. The purposes of that notice requirement is to give the state an opportunity to, if they choose to file a motion in limine, or to do additional discovery. Now, on the other side of that calculus, the state clearly was aware of these.
Judge, on the notice issue, the state waived.
Okay, I was about to get to that. I think the state had notice of these statements, knew about them all along. So I am going to limit it to the extent that the defense intends to introduce prior bad acts by the alleged victim that go to the defendant's state of mind. I think they're limited to those which have been previously disclosed in the defendant's statement. They're not to go beyond the four corners of the statement that's been previously provided to the state. I did review Newell as well, counsel. I looked at it. I think that's a slightly different issue there. Newell is focused on the character evidence side of this. In that case involved a prior criminal conviction that they were trying to bring in to show character specifically. It wasn't dealing specifically with prior bad acts directed at the defendant by the same victim. And that Woodburn is on point on that. All right. So with that, I'm sorry? Yes, please. We're going to take a 5-minute recess. We're then going to bring the jury out, and we're going to start with the state's case, defense case. Very good.